Hello everyone and welcome to this session on key concepts in data protection law. My name's Eleonor and I'm a lawyer at Fieldfisher in London. This is part of a series of sessions called Get Data Protection Fit. And what's the idea behind that? Well, we're going to be giving you the basics of data protection law, and then in time you will be moving up the levels and understanding more, not only about the foundations of the law, but about more sophisticated things. How do you use it in practice and to best effect? So this is part of our first module in Get Data Protection Fit. It's called Key Concepts, as I said, in data protection law, and we'll be moving through, as time goes on, to all 6 modules which are mentioned here, so all 6 segments in this module. Next we'll have the data protection principles, and then we'll go on to the grounds for processing personal data, the rights of the data subject, what needs to go into a privacy notice, and finally international transfers. So those are all the segments in this first module. So what am I going to talk about in this first session? Well, firstly, I'll take you through the history of data protection law because I think it helps to think about it in context. Secondly, I'm going to be talking about current data protection legislation, and I'm going to be going through the key concepts, including the main elements of data protection law, key principles, the rights which the law confers on individuals, and finally transfers of data. So what are the learning outcomes for this session, and how will you know that you're making that first step, as it were, on the data protection Get Fit journey? Well, by the end of the session, you should be able to explain why we have data protection law and the main concepts and principles. So I'm going to start off now with the history, and this is a rather old and beautiful monument in Jordan, in fact, and I think the history of data protection law actually goes back much further than we would expect. On this slide, I've mentioned the Magna Carta from 1215. Why have I done that? Well, before I became a data protection lawyer, I went to my first ever lecture on data protection law, and the speaker said something which I think was really interesting. He said that for centuries in the UK, we fought for our rights in the real world, and now we're having a fight for rights in the digital world. And he talked about the writ of habeas corpus. Now, in the Magna Carta, it set out that nobody should be subject to imprisonment without being able to be taken before a court and to challenge that imprisonment. And the writ of habeas corpus comes from medieval Latin, meaning that we, the court, demand that you bring before us the body of the detainee to decide whether the imprisonment's lawful. And that was a really crucial journey in human rights in the UK all that time ago. And as I say, the way of thinking about data protection law perhaps is that we're now trying to establish those same rights, but in our new world, in our digital, virtual world. So data protection law does have deep roots, and in terms of legislation, it has roots in human rights legislation, and in particular the European Convention on Human Rights and the right to a private and family life. One thing that's really important to remember about data protection law is that it is not about absolute rights. Data protection isn't an absolute right. It has to be balanced against other rights. So, for example, when you're thinking about how data protection is relevant in a particular context, you'll be balancing the rights of the individual on the one hand against the rights of a business or against the rights of government or other entities on the other, and deciding where that fair balance lies. Whose rights are paramount in that situation, the individual or the business or government or other entity? So that's a really crucial concept in data protection law. I'm coming on now to look at the data protection framework that we have in place at the moment. And we have two instruments, and I've put them up on the slide here. They're the really crucial ones. The General Data Protection Regulation, or GDPR, which is quite well known, I think. When it came in, there was lots of talk about it and the rights that it gave people and the huge fines as well. The thing to remember about the General Data Protection Regulation, and we're going to be explaining a lot to you about it in this session and going on the future sessions in this module, what it does is it sets out rules for how you process people's personal data. And then linked to that and underneath that is national legislation. In the UK we have the Data Protection Act 2018, and very broadly speaking that sets out exceptions to the rules. So the way in which these two bits of legislation interact is that you've got, as I say, the rules in the GDPR and underneath that the Data Protection Act with the exceptions. So how should you think about data protection law? Well, in some ways you could think about it as a house. What do I mean by that? Well, there are some main elements which I'm going to take you through in a moment, and they're like the bricks, the main building blocks of the law, and they give it its shape and its weight and its substance. And then after that, there's cement. And in data protection terms, those are the principles. They flow through data protection law. They hold it together. They're the thing that makes it coherent, as it were. So the principles are a bit like cement. And then, of course, the house is there mainly for individuals to give them protection, to be a safe space for them to exist in. And so rather like a house, data protection law gives people rights and protects them in this digital world. And finally, the house also, of course, sits in its environment and it has an effect there too. And so I'm going to be talking about that as well, the fact that data protection law applies also outside its borders, as it were, and continues those protections in the house out into the environment. So we're coming on now to looking at the building blocks of data protection law and the key concepts, the key elements. And the first one is personal data, and it's a really important concept. And it's about identifying people. So personal data is any information that identifies them. So for example, as I've set out on the slide, their name or their social media username, their home address, their ID card number, or their image, like this picture of this lady here. These are all things that identify people, and they're all personal data. But personal data is also slightly more complicated because it's not only about information that directly identifies somebody, also is about information that could indirectly identify them. And that's why I've got this picture of the head with bits of a jigsaw, as it were, missing, because those little bits of information which together would make up someone's identity, as it were, are also personal data. So if you could put one piece of information together with another and another, and there through that process identify somebody, then those bits of information are also personal data, and they also need to be protected. This is often called jigsaw identification, as I said. So that's personal data, anything which directly or indirectly with other information makes someone identifiable. The next concept in data protection law, which is really important, is processing. Now, what's that? Processing is anything that you can do with data. So we've given some examples here on the slide. It's collecting it, recording it, storing it, using it, even deleting it is all processing. And so a lot of the legislation will be looking at processing of personal data, anything you can do with personal support by the legislation. The next really important concept is special categories of personal data, and I've put a huge padlock there in the corner of the slide, because special categories of personal data are sensitive and need extra protection in the legislation. So what are special categories of personal data? Well, I've set out some examples there. Data about people's health, their religious beliefs, their political opinions, their sex life or sexual orientation, or their racial or ethnic origins. Those are all given special protection in data protection law. And here's another key concept of controller and processor, and I've illustrated it in this picture here. So the lady sitting there getting her drink is a bit like a controller in data protection law. She's decided what she wants. She's the person in charge and making the decisions. And so here she's asked this lady, obviously, to bring her what she would like to drink, but turning that into a more data protection relevant context. A controller decides what to do with personal data. So they might use it for marketing purposes, or they might use it in order to reach out in different ways to customers. So they decide, they make business decisions or other decisions about what is done with personal data. And the processor is illustrated by the lady here on the left who's serving the drink. She is acting on the instruction of the controller. So she isn't making decisions. She is simply doing what she is asked in order to provide a service to the controller. And in data protection law terms, the processor will do things like providing a cloud computing service, for example, for the storage of personal data on behalf of the controller and acting on the controller's instructions. So they're not deciding anything about the data. They're simply producing a service, as it were, in order to assist the controller in their own functions. So that's controller and processor. And finally, in this segment on the key elements, the key concepts, is the data subject. And that is the person who the data is about, the person who the data identifies. So now we're coming on, if we're thinking of the house again, to the cement, the thing that holds data protection law together, as it were, and that's the data protection principles. So what are they about? Well, they're about the way in which you process data, and I've set out on the slide a few examples of some of the principles. So you should process data fairly, and you'll see that the first picture is some fair trade coffee beans. What does that mean? Well, it means that you should take into account what people's expectations are about how their data will be processed. You shouldn't be processing it in a way that they wouldn't have anticipated and that would surprise them or be unfair on them. Data protection legislation also requires you to process data lawfully. That's in accordance with the legal framework set out in data protection law and also other legislation, making sure it's all compatible with that. And I'll come on to lawful processing in a tiny bit more detail in a moment. But basically, you have to process it in accordance with the structure set out in the GDPR. You have to process personal data transparently. You have to tell people what you're going to be doing with their personal data. That's also a really key principle. And finally, we've heard so much about security breaches and personal data being lost and compromised. And the security principle is also really, really key. So those are a few of the key principles, and we'll be going on to all of this in more detail as we go through this module. Now, I talked just a moment ago about the principle of lawful processing, and data protection legislation, the GDPR, sets out a framework to ensure that the processing is lawful, and it sets out bases which, if met, will allow you to process data lawfully. So what are they? I've put up a few examples here on the slides. So you must process personal data in accordance with any of these and other lawful bases. But the first example I've given is consent, that people say, yes, I'm happy for you to process my personal data. Second example is where you're processing on the basis of a legal obligation. Say, for example, when you're sending in your tax return, you've got a legal obligation to do that, and Her Majesty's Revenue and Custom also have legal obligations in relation to the processing of that data. So that's an example, processing on the basis of a legal obligation. And the third example I've set out here is legitimate interests of the controller. And as you see, I've got the scales again here. And this is such a key concept, as it were, in data protection law, but also in relation to the lawful basis for processing. So in this legal basis, you're weighing on the one hand the rights of the individual, the data subject, to privacy and protection of their personal data, against other rights, like the right to run a business or the right for an authority, perhaps, to do certain things, and weighing up what's fair here. Where does the balance lie? Is it in favour of the individual, or is it in favour of the entity that wants to do something with it? So that's legitimate interests, and provided the data subject's rights are not overridden and compromised by what you want to do with the data, then you usually can do whatever you're intending. And that's another point about data protection law. It does actually, if you apply it properly, make sense. So if you've got legitimate reasons to be processing someone's personal data, the chances are that you will be able to do that and to meet this particular legal basis. So that gives you a flavour of a few of the lawful bases of processing, and we'll be going on to those in later sessions and looking at them in more detail. And now the rights of data subjects. So going back to the house analogy, this is the protections that data protection law affords, as it were, to the people who are encapsulated within it, as it were, and with the house analogy, the people living in the house. What does it do to benefit them? Well, it gives people certain rights. And I've put a few examples up here on the slides. So the first is the right to access personal data. And this is really important because there's a perception, a correct perception, that if you're able to access your data, you'll be able to enforce other rights. Say, for example, if your employer has mistreated you and you've had to leave your job, you can ask for access to the data that your employer holds about. And in order to consider whether or not you need to go to a tribunal, perhaps, in order to enforce your rights in the employment law context. And so the right of access to personal data is really important in order to allow you to enforce those other rights in the employment sphere. So that's one example. The next right is the right to have your personal data deleted. So we all put up pictures, we perhaps post blogs all the time online, and in the course of a few years, you might decide that you don't want that particular picture up, or you don't want your blog, for example, to always be available when someone searches for you. In certain circumstances, you could ask for your personal data to be deleted. And also the right not to be subject to automated decision making. That's so crucial nowadays and will be even more important in the future when artificial intelligence is able to come up with evaluations, perhaps, of people's performance or their attributes. Data protection law provides protections so that machines aren't making really important decisions about people, which people are not able to challenge or get another human being, as it were, to check the output of the machine which has made a determination about a person's qualities. So that's the right not to be subject to automated decision making. And finally, when we talked about the house, I talked about the house in the context of the wider environment. And in terms of data protection law, to translate that into this context, data protection law protects personal data, even when it's outside, when it's traveling, as we know it does, all around the world in a split second. Even then, data protection law confers rights and protections, so that even though the data has moved away, as it were, from that protected environment, it's still kept safe. So we're coming to the end of the session now, and you'll remember that I talked about the learning outcomes at the beginning and said that by the end of the session there were certain things that you should feel that you'd managed to grasp, that you'd managed to achieve, that you'd understood. And I'll just run through what we've talked about, and hopefully this will resonate with you now and you'll really feel that you've been on a journey of understanding what data protection law is about. So I said that you should be better able to explain why we have data protection law, and we talked about how data protection law is about human rights in the digital world, that there are rights that we've fought for centuries in the real world, which we're now establishing in that digital virtual space. And I talked about the rules, the law that we have in place at the moment to protect our personal data. The General Data Protection Regulation, or GDPR, which sets out the rules for protection of personal data, and our National Data Protection Act 2018, which sets out the exceptions from the rules. Next, I said that you should be better able at the end of the session to explain the main concepts and principles in data protection law. So we talked about personal data. We talked about data that directly identifies an individual, but also data that indirectly identifies an individual, where you have that jigsaw puzzle, where you've got little bits of information which put together identify someone. Those are also personal data and they need to be protected under the legislation. We talked about processing, which is basically anything that you can do with data. We talked about special category data that has extra security, which is kept extra secure in the legislation. So that's data about health, religious beliefs, political opinions, racial, ethnic origin, or sex life or sexual orientation. We talked about the concept of controller and processor. The controller is the decision maker, makes decisions about how the data is going to be processed, and the processor acts on those instructions on behalf of the controller. We talked about the data subject. That's the person who the data is about. And then we talked about the data protection principles. We talked about how data should be processed fairly, lawfully, transparently and securely. And then we also talked about the lawful grounds for processing, consent, legal obligation, and that balancing act, the legitimate interests of the controller against the rights of the data subject. And then we talked about what rights data protection law confers on individuals, on data subjects. So the right to access their data, the right in certain circumstances to have their data deleted, and the right not to be subject to automated decisions about important things in their life. And finally, we talked about international transfers of data, how even when data is sent across borders, it should still be kept safe, respect those protections that data protection law confers. So, we've now finished the first segment of Module 1, Key Concepts in Data Protection Law. Next time, we'll be talking in more depth about the data protection principles which we touched on in this session. And this is me and my contact details and a little bit about our team in Fieldfisher, the technology outsourcing and privacy team. Thank you very much indeed for listening, and I hope you feel you're now starting your journey on getting data protection fit. Thank you.